Hello, my name is Georgia and I'm this year's Secretary at Trinity FLAC. We are so excited to introduce our second discussion on Wardship with Patricia Brazel, the Averil Deverell Assistant Professor of Law, and Finn Keys, Adjunct Assistant Professor of Law from our very own Trinity Law School. This discussion is about the Irish system of wardship. In Ireland, a ward of court is the term used for a person who is deemed by the courts unable to look after their affairs and who has somebody appointed to do so on their behalf. This system is similar to the system of conservatorship in the United States, which has been in the news recently due to the Free Britney movement. It will touch on the realities of the current system, one that is considered by many to be outdated and in need of change, as well as the legal test for wardship and calls for reform in this area. Thank you so much to Mr. Keys and to Dr. Brazel for sharing your expertise with us.
Hi everyone, thank you for inviting me to speak to you today about wardship. My name is Patricia Brazel. I am the Averil Deverell Lecturer in Law in Trinity, and I'm also a practicing barrister, including in the area of wardship. So I was asked today, I suppose, just to speak to you about my perspective on wardship, and I know that many of you are interested in the issue in the whole context of the Free Britney movement and the interest in the whole idea of wardship or conservatorship, as it seems to be known in the United States. So wardship in Ireland is very much, a 19th century construct. The law on wardship dates from the 1800s and to this day still hasn't been updated. And I'll come back to talk about that. There is plans to change the law, very long overdue and much needed plans to reform the law. But for today, any person who goes into the wardship system or has a case determined under the wardship system is actually being dealt with in a system that comes from the 1800s. The test for whether a person should be made a ward of court is whether they are of unsound mind and lack capacity to manage their person or property. And as I say, because the law in this area comes from the 1800s, that's at a time when, knowledge and understanding about mental health, intellectual disability were really just in their infancy, if at all. So today, in the 21st century, the concept of being of unsound mind really doesn't have very much medical basis. This is an issue sometimes medical examiners will raise when they're asked to give a report in a wardship case, that the test they're being asked to apply doesn't really fit into modern medical practices because they don't use language such as a person of unsound mind. So what ends up happening today is that very often we're working within this very antiquated, old-fashioned system, and people try to adapt as best they can to work within that system pending changes in the law. Most people who end up subject of wardship proceedings will generally fall into one of two categories. A person may either have mental health difficulties that affects their capacity to make decisions for themselves, or the person may have an intellectual disability. In either case, the question ultimately in the law as it stands is whether by reason of that condition, the person doesn't have capacity to manage their person or property, and that's a global test. It's a very amorphous, very general, or I suppose a vague test. And again, it doesn't allow for more nuanced consideration of a situation where you might have a person who perhaps lacks capacity in one area of their lives. Perhaps a person doesn't have the capacity to manage their money, but does have capacity to make decisions about other areas of their lives. The wardship system that we operate under is very black and white. It's all or nothing. You either have capacity to manage your person or property or you don't. And if you don't, or if you're deemed not to have that capacity, then you are admitted to the wardship system. So what does it mean to be made a ward of court? If a person is found to be of unsound mind and not to have capacity to manage their person and property, then they are declared by the President of the High Court to be a ward of court. And thereafter, all decision-making capacity on their behalf no longer resides in the person themselves. It's actually transferred to what's called the Committee of the Ward. And at the time that the High Court declares a person a ward of court, the High Court will nominate a person or a group of people to act as the committee. And these are the legally responsible individuals who are going forward going to have all of the power to make decisions that affect this person's life. Very often, if it's a fairly straightforward situation, if there's no complexities or no difficulties, it will be the family who will be appointed as the committee. So many cases that come before the court would either, for example, involve an elderly person who has declining cognitive function. And very often there will be children, adult children involved in that person's life. So it might be appropriate to appoint those children as the committee so that they can make decisions going forward. They will be the people who would know best the individual who is referred to as the ward, and they would be the people who would be probably best placed to make decisions on their behalf. Children can also be made wards of court. The test for making a child a ward of court is different. It doesn't require unsoundness of mind, because children under the age of 18, as a matter of Irish law, are automatically deemed not to have capacity in general terms. So the test for whether a child is admitted to wardship is essentially whether the child needs the protection of the court for some reason. And the kinds of cases where this often arises in relation to medical treatment. If a child requires medical treatment and the parents can't agree about that treatment, or there's a dispute between the doctors and the parents, then sometimes it might be necessary to make an application to the High Court and ask the High Court to admit the child to wardship, and then for decisions around medical care to be made by the President of the High Court. And that happened quite recently in a case called JJ. I don't know if some of you might be familiar with it. Involving a very sad case of a young boy who had suffered catastrophic injuries in a car crash, I think it was. The hospital effectively believed that life-prolonging treatment was not in his interest, that he would never recover, whereas the parents, for very understandable reasons, still held hope that he might in the future recover. The hospital basically wanted permission to not provide any, certain types of medical treatment aimed at prolonging his life, that if he went into, for example, cardiac arrest, I think that he wouldn't be perhaps resuscitated, because ultimately his quality of life was so minimal, and he actually was experiencing pain as a result of his condition in the hospital. And that's a case that went all the way to the Supreme Court about the test for resolving difficult, very sad cases like that. When the committee is appointed, as I say, they have now the decision-making capacity to make decisions on behalf of the ward. And this is potentially quite controversial because of the impact on the individual's autonomy, and because, as I say, the test for wardship is so black and white, and it doesn't really, on the face of it, the current law doesn't allow for more kind of case-by-case decisions about what areas of a person's life they should be left with decision-making autonomy. There have been a lot of calls for reform of the law in this area, groups working on behalf of people with intellectual disabilities, various law reform groups, SAGE, advocacy on behalf of older people. The laws in many other countries have been changed to reflect a more nuanced, a more case-by-case response to people who may have capacity issues in some areas of their lives. The Oireachtas did pass the Assisted Decision-Making Capacity Act in 2015 that was designed to replace the current wardship system. And it was designed to replace it with a more flexible and a more 21st century appropriate model for dealing with people who have cognitive or intellectual impairments. The problem is we are now in 2021. We have a piece of legislation that was passed 6 years ago that is still not fully commenced. And that's not unusual in Ireland, but it's certainly not desirable. And so for as long as we don't have that new law in force, we're still operating under the old system. The situation of Britney Spears, I'm not an American lawyer, I'm not an expert on conservatorship, but I can say from what I've read about it, I'm following it with interest, as I know many of you are, some of the issues that seem to have given rise to tension in her case are in the powers of what we would call the committee. In her case, I think it's the conservator or her father who is acting as the committee, is my general understanding, around the use of financial resources or how her money was being managed and spent. She claims that she was being medicated against her will. She says that she was refused effectively permission to have a child, that she was basically forced to take contraception, or I think an IUD or something like that. Those are all the kinds of decisions that in Ireland a committee would in theory be entitled to make on behalf of a ward. And there are stories, or you will find as part of the law reform campaigns, people who have been the subject of wardship talking about the impact that system or that kind of system can have on their lives. I know there was a report a few years ago calling for reform of the law in this area. There was a young woman who had been made a ward of court, who I think she had a relatively mild to moderate intellectual disability, who was in dispute with her committee. She wanted to buy, it's such a simple example, she wanted to buy a pair of shoes. She saw a really nice pair of shoes and she wanted to buy them, but the shoes were €100. And the committee said, but you don't need €100 to buy those shoes. You can buy shoes in Dunnes for €20. And And she was saying, that's my money. I want to buy those shoes. But she didn't actually have the power to make that decision for herself. Her committee controlled her bank account, and her committee refused to authorise her €100 from her own bank account because the committee ultimately has the power to make that decision. It's a very paternalistic model. It's what we call substituted decision making, where somebody else is making a decision on behalf of somebody else. And the real concern is that it doesn't sufficiently respect the rights of the individual who's the subject of the process, and that it's a disproportionate interference with the rights of the individual. Certainly, as I say, today, the Irish system, because it's based on this 19th century model, is very much outdated. It's very much in need of reform. I was involved in a case last year that's still ongoing about a lot of these issues, so I'll be slightly careful about what I say because it's still ongoing. I act on behalf of a man who was the subject of an application to be made a ward of court. He has a moderate intellectual disability, and he wanted to get married to his partner of many years, who also has an intellectual disability, although she's slightly higher functioning than he is. The night before their wedding, an application was made to the High Court exercising its wardship jurisdiction for an injunction restraining the marriage on the basis of the Marriage of Lunatics Act of 1811, which at that time was still in force. And the Marriage of Lunatics Act in Ireland basically says that a person who is a ward of court can never get married. They automatically lack capacity to marry, and any marriage that takes place is null and void. I acted on behalf of him with a legal team instructed by FLAC, so very relevant to the organisation that you're here today for. We ultimately brought a separate case on his behalf challenging the constitutionality of the Marriage of Lunatics Act and also the constitutionality of the entire wardship system, because we said it was a disproportionate interference with his personal rights. The case, there's been a partial resolution. The state agreed to repeal the Marriage of Lunatics Act of 1811. Ireland had long been criticised. Even the language of lunatics is so inappropriate and old-fashioned. So the state has actually repealed that act as a result of the case, and that's one very positive development that has occurred. The other part of the case concerned a challenge to the broader wardship jurisdiction. And what's happened is that the state has given a commitment to commencing the 2015 Act in full by mid-2022. And on that basis, we haven't proceeded with our constitutional challenge, because if they can get that new law up and running by mid-2022, that's probably quicker than we could actually proceed with our constitutional action, which is likely to end up, I think, being appealed by whoever loses. So at the moment, we're in a bit of a stalemate situation. We're waiting to see if the commencement of the 2015 Act does happen. I very much hope that it does, but there's a lot of work that still needs to be done on the ground in terms of preparing the structures and the supports that are needed to put in place this new system. So for the moment, we're still operating, as I say, under this very old-fashioned, probably really quite inappropriate remedy, and the hope is that change will come sooner rather than later. Okay, thanks very much for listening to me, and I hope you enjoy the rest of the seminar. Bye.
Okay, hello everyone. Very much like to thank Trinity FLAC for asking me to speak on this important issue, namely the law of wardship in Ireland, something that not many people tend to be that familiar with the detail of. I hope to be able to give you a broad outline of the jurisdiction and how it operates in Ireland. First of all, apologies for the state of my voice. I hope it isn't too disconcerting. I'm feeling slightly under the weather. So the President of the High Court has a wardship jurisdiction that is highly consequential, but is sometimes lesser understood, particularly by members of the public. This is a matter of some concern, given that the scope of wardship. So there are 3,000 wards of court, with the President of the High Court, through the Wards of Court Office, managing nearly €1 billion in combined assets of wards. So what exactly is the jurisdiction in wardship? So the jurisdiction in wardship is governed by the Lunacy Regulation Ireland Act of 1871, and it arises where a person is of unsound mind and is incapable of managing their property and affairs. Where those circumstances arise and are proved to the satisfaction of the High Court through medical and psychiatric evidence, the President of the High Court can admit them to wardship for the purposes of managing their affairs. This is sometimes simply the managing of property and assets, but it can extend to life or death decisions governing medical health care. Somewhat surprisingly, the phrase of unsound mind is not further defined in the law, and the circumstances in which a person can be deemed of unsound mind are very varied. Law students may be familiar with the famous case from the mid-90s of In Re Ward of Court, an assisted dying case, where the ward was in a near permanent vegetative state. However, that is by no means always the presentation of persons who are made a ward of court. Common examples of persons who are made wards include people with advanced dementia, people with severe anorexia, and people with a variety of schizoaffective disorders, among others. And the category of difficulties that can arise to ground admission to wardship are not closed. So the jurisdiction is essentially a protective in nature, and it's premised on the understanding that persons lacking capacity can be vulnerable to exploitation. However, it has to equally be acknowledged that wardship constitutes a severe restriction on the fundamental rights and liberties of persons who are often ill-equipped to resist the admission to the jurisdiction. So a person who's made a ward of court, they effectively lose the right to make the most decisions about their person and their property. They cannot enter binding contracts. They cannot institute or defend legal proceedings. They cannot buy or sell property. They can't have a bank account, and they can't travel outside the country without the permission of the court. And until very recently, with the repeal of the Marriage of Lunatics Act earlier this year, they couldn't marry. So it does constitute quite a severe restriction on the fundamental rights of these persons. So it has to be a jurisdiction exercised with considerable care. It can be triggered in two ways under Section 15, two primary ways, I should say. So Section 15 and Section 12 of the Lunacy Regulation Ireland Act of 1871. So either a next of kin can bring the application, or the President of the High Court herself can institute the proceeding. Following admission to wardship, a committee is established. The committee is a person, confusing, and the committee, there can be two committees, a committee of the person and the committee of the estate. The committee of the person is a person appointed to take care of the personal decisions relating to the ward, including their day-to-day life and their medical affairs, while the committee of the estate is appointed to govern financial matters related to property, etc. So the committee oversees, both committees in tandem oversee the welfare of the ward and can make applications to the Ward of Court Office of the High Court and to the President herself for orders as to the care, resident and management of the ward's affairs. So the President of the High Court conducts regular reviews into the welfare of the wards by reference to psychiatric and social work reports. So that is the outline of the jurisdiction. I realize I'm a little bit up against time here. I've only been asked to speak for 5 minutes, so I'll skip over some of the interesting historical development of the jurisdiction. The jurisdiction is a passover from the old what's called the parens patriae jurisdiction of the king to look after the those of unsound mind in the Kingdom of England, but now has moved to the President of the High Court on post independence. But briefly, going forward, the jurisdiction is wildly outdated, and the continued use of terms such as lunatic and lunacy, etc., are not appropriate. And similarly, it is considered increasing out of step with a modern understanding of the rights of persons with disabilities, and in that it provides for a sort of all or nothing approach to capacity. And while the High Court does give increasing weight to the voice of the ward in such proceedings, it remains considered out of step with international best practice, particularly in light of Ireland's ratification of the UN Convention on the Rights of Persons with Disabilities. As a result of this, the wardship jurisdiction will not be with us for too much longer. This is a Decision-Making Capacity Act of 2015, when fully commenced, will repeal the Lunacy Regulation Ireland Act of 1871 and abolish the High Court's wardship jurisdiction, albeit subject to certain transitional arrangements. I won't address you fully on the Decision-Making Capacity Act, but suffice to say that it will significantly alter the manner in which the state deals with the welfare of persons with issues of capacity. That's pretty much all I want to say. Thank you very much for listening. I hope that was useful and somewhat enlightening, and apologies once again for the terrible state of my voice. So best wishes, and thanks once again for inviting me to speak.